Good afternoon. My name is Malcolm Rich. I'm the Executive Director of the Collaboration for Justice. I welcome you to the Spotlight on Pro Bono on behalf of the Collaboration for Justice of Chicago Appleseed Center for Fair Courts and the Chicago Council of Lawyers. For nearly 25 years, our two organizations have worked together to promote a system that is reforming of our justice system, including criminal justice reform, access to justice, children and family reform, immigration court reform, and police accountability. We research to support community-led and community-supported solutions to systemic injustices. We advocate for equitable, evidence-based, anti-racist policies and practices that make our legal system more accessible and less harmful. We educate the public on how to best access their rights in court and educate legislators, lawyers, community activists on how to improve access to the legal system for their constituents, their clients, and their communities. Today, we want to acknowledge those firms, organizations, and individuals with whom we work to bring practical, effective, and meaningful solutions to injustices. But first, I want to acknowledge our senior staff, the backbone of our organization. Senior Policy Analyst Sarah Stout, who you'll hear from shortly. Communications Manager Stephanie Agnew, Research Manager Grace Mueller, and Elizabeth Munkus, who leads our work on family law reform and on domestic violence courts. And I also want to thank our undergraduate student interns, our law students, our placement students from the Crown School of Social Work at the University of Chicago, and our Appleseed Network and Collaboration for Justice fellows. And now I want to acknowledge our pro bono partners. We acknowledge the Civic Federation and Alexandra Block, a partner at Miller, Shackman, Levine, and Feldman, for their work on new directions for the clerk of the Circuit Court of Cook County. Their two reports provide a detailed blueprint for what the community expects from an exemplary clerk's office. And this is an ongoing program. We want to acknowledge Lindsay Hagee, Jonathan Pilsner, Dr. Mary Patillo, Cabrini Green Legal Aid, Chicago Bar Foundation, John Amdor, and the law firm of Baker and McKenzie for their work in helping us lead a coalition which led to the Criminal and Traffic Assessment Act, which created a waiver of court costs and fees for indigent defendants. We want to acknowledge the People's Lobby and Reclaim Chicago for their collaboration with us in producing 8 and counting data-rich reports on progress being made by the Cook County State's Attorney's Office toward changing the win-at-all-cost culture, so prevalent among prosecutors' offices here and around the country. We also want to acknowledge the law firm of Foley and Lardner for their pro bono assistance in both past and future research efforts in this regard, in regard to basically monitoring the State's Attorney's Office of Cook County. We want to thank our coalition partners, including Cabrini Green Legal Aid, Chicago Volunteer Legal Services, Lawyers Committee for Better Housing, Legal Aid Chicago, Legal Aid Society of Metropolitan Family Services, Updowns People's Law Center, for work around ensuring a court record in eviction court. Because a record is now being made, judges are accountable. Tenants can appeal their evictions with pro bono assistance, and Zoom eviction proceedings are now being recorded. We want to acknowledge our collaboration partner, Chicago Votes, for our work in helping educate voters in judicial elections and retention elections through our voteforjudges.org website and for creating a community court watching program, which will allow for an objective and research-based review of judicial performance around the issues of procedural fairness, temperament, and bias. We want to acknowledge the ongoing work of pro bono partners at Kirkland and Ellis and Skadden Arps in our work to develop proposals around diversion courts within the Circuit Court of Cook County, including the Access to Community Courtroom 201, which we helped design, implement, and manage. We want to acknowledge the law firm of Latham and Watkins for its work in developing the hearing officer program within the Domestic Relations Division of the Circuit Court of Cook County, our work around proposed improvements in immigration bond hearings, and now our work in implementing the Pretrial Fairness Act, which will end money bond in 2023. Finally, we want to acknowledge the law firm of Goldberg Cohn for their pro bono work in our research and advocacy around creating central panels of administrative hearing officers through which this hidden judiciary can be more independent and receive better training and supervision. Our research was used to help create an Illinois central panel and state central panels throughout the United States. We thank those pro bono partners greatly. Now, one of our recent successes has been the role that we've played in enacting the SAFETY Act, which includes the Pretrial Fairness Act, which will bring an end to money bond in 2023. As one of the founding members of the Coalition to End Money Bond, we are proud of this accomplishment, but know that the road ahead toward implementation of the Pretrial Fairness Act will be challenging. Here to discuss the act and its implementation is Sarah Stout, our Senior Policy Analyst.
Hi, everyone. My name is Sarah Stout, and I am the Senior Policy Analyst and Staff Attorney for Criminal Justice Matters here at the Chicago Appleseed Center for Fair Courts and the Collaboration for Justice. I want to talk for just a couple minutes about the Pretrial Fairness Act and the amazing accomplishment that its passage is, and also how much work there is yet to do that we will need support in going forward. The Pretrial Fairness Act is, I think it would be reasonable to say, one of the largest reforms to Illinois' criminal justice system in history. In one piece of very long legislation, the Pretrial Fairness Act components are, I think, about 400 pages of the 750-page SAFETY Act. The bill does a number of things that make us the first in the country and give us what I really do believe is the best pretrial law in the country, in terms of promoting fairness and equity and making sure that we use jail only as a last resort in pretrial situations. The first thing it does, which is the one that gets the headlines, is that it makes us the first state to fully abolish money bond. After January 1st of 2023, no one in Illinois charged with anything will be required to pay any money to secure their freedom. Money bond is a fundamentally unjust and irrational system. It's the exact kind of system that I think Appleseed really excels at trying to reform and tear down, because not only is it incredibly unfair and creates radically disparate racial outcomes within our criminal justice system, but also just doesn't make any sense. There's no relationship, of course, between the amount of money that you have and whether or not you might appear in court or whether or not you pose any danger to any other person. But the Pretrial Fairness Act does a lot more than just eliminate money bond and leave us with nothing. It replaces the end of the money bond, replaces money bond with a system that focuses on giving full due process and robust hearings to anyone the state is trying to put in a cage. That means that it makes certain charges that are relatively low level completely ineligible for jail upon first arrest, so that we don't have a situation where every single person moving through our judicial system at any point feels they have the possibility of being sort of plucked out of their lives and put into a jail cell. That's not the way that we should be treating people who enjoy a presumption of innocence. Even for the people who are actually eligible for jail, our hearing system is more robust. The hearings will be longer. They will have more evidence presented, and the judge will need to find that jail is the only way to assure the safety of other people in order to jail a person, or that they bear a high likelihood of willfully fleeing prosecution. Those standards are the highest standards in the country, and they should be. What we need is a system that understands that jail is, in fact, the last resort. Release should be the norm, and detention a carefully limited exception, as the U.S. Supreme Court, I should say, has stated. That has never been a reality in the United States, and the Pretrial Fairness Act gives Illinois the chance to be the first. I'm incredibly excited about this act. We could not have done it without the help of our pro bono partners and all of the people who work with Chicago Appleseed and the Chicago Council of Lawyers to help put this legislation together. It's incredibly long, it's incredibly complicated, and as one of the primary drafters of the legislation, I relied heavily on all of those wonderful lawyers who work on our criminal justice advisory committee and with other parts of Chicago Appleseed and the Collaboration for Justice to look through all of that language, to give feedback, and to make sure it's the best that it can be. I'm going to give a special shout out to Jonathan Pilsner, without whom I'm pretty sure there would have been things in this act that just would not have worked once we actually put them into practice. And being able to have, sets of eyes on legislation who are among the most talented lawyers in the state is incredibly valuable. So that's incredibly exciting. I am incredibly proud to have done the work that we've done, to have been a founding member of the coalition, and to have passed the Pretrial Fairness Act in January. So now we need to change 102 counties' whole procedure for dealing with pretrial justice, and we have about a year and a half to do it. It's a huge undertaking. We need to train every judge in the state. We need to make sure that our prosecutors and our public defenders know what's coming. We need to make sure that everybody in the court system, whether they wanted this bill to pass or not, understands that it's the law and that we need to implement it fairly. And we need to make sure that we're collecting all of the data that we possibly can and analyzing it so that we can prove what we do already know, which is that bail reform is safe and effective and more fair than what we have right now. We're also going to need to hold back the tide of a huge amount of backlash that's trying to get rid of these reforms before they've even been put into place. I know I will be relying on the same people that I relied on as we passed the bill, and I hope I will be able to rely on a lot more of you as we start to move into this fight of implementing the bill. This is the stage where two different states, California and New York, have arguably failed to make their dreams of bail reform a reality. And it's not going to happen to us. It doesn't have to. The coalition behind this bill is incredibly strong. The lawyers behind this bill are incredibly smart. And I truly believe that with hard work and partnerships like the ones that we're celebrating today, we can really do a phenomenal job and make Illinois the leader in pretrial justice. I am really looking forward to that hour and that year and a half task, even though it's going to be hard, because I know that I will be able to do it with all of you. Now I'm going to pass it back to Malcolm to introduce our keynote speaker.
It is my honor today to introduce our keynote speaker, Dr. Traci Burch. Dr. Burch is a research professor at the American Bar Foundation and associate professor of political science at Northwestern University. Dr. Burch's research focuses on the United States criminal justice system, political behavior, and structural inequality. She's the author of Trading Democracy for Justice, Criminal Convictions and the Decline of Neighborhood Political Participation, and the co-author of Creating a New Racial Order. Other recent publications appear in Political Behavior, Law and Society Review, and Criminology and Public Policy. And I want to add that her influential testimony in litigation surrounding court costs and fees and its relationship to voter suppression in Florida is a shining example of how research can have an impact on policy. We welcome Dr. Traci Burch.
Thank you so much, Malcolm, for that wonderful introduction and for the invitation to speak today. I would also like to congratulate Chicago Appleseed and the Collaboration for Justice and all of you for the accomplishments over the past year, including the Pretrial Fairness Act and the Safety Act. Changes such as the abolition of money bond, I feel like they were unimaginable almost 10 years ago, but thanks to your work, this progress has become a reality. And there's still a lot more work to do, as Sarah just mentioned, but I think that even this amount of progress gives everyone watching you and who wants to participate in this process hope. And I just want to thank you for your work. So today I want to talk to you about my latest project, which looks at the role of the public in responding politically to officer-involved killings. And I think this is important because we rely on the public in many cases to kind of be our partners, but also to set up the opportunities for progress to happen. So I just want to talk about one aspect of my new project today, which is who gets protested, and to help us think about what factors shape the protest of officer-involved killings. And so we're just going to look at victims of these killings today to think about how the public responds to their deaths. So I'll start by recapping a very familiar recent history, just to remind you that it was just almost a year ago, on May 25th of 2020, when 4 Minneapolis police officers arrested George Floyd based on allegations that he tried to pass a counterfeit $20 bill. That bill turned out to be real. Officer Derek Chauvin was videotaped kneeling on Mr. Floyd's neck for over 8 minutes during the arrest, and Mr. Floyd died, as many of you saw. Chauvin was convicted of murder just last month. So as a result of Mr. Floyd's death, public outrage over police violence boiled over into the streets at a record pace. And these protests were large and sustained. The Armed Conflict Location and Event Data Project examined almost 8,000 demonstrations that against police violence that took place between Floyd's death on May 25th and August 22nd of 2020. And they found that these demonstrations took place in 2,400 places across the country and the world. And overall, 93% of those protests were peaceful. And they define peaceful as having no reports of violence or property damage. 4 surveys find that between 15 and 26 million Americans participated in one of these protests, even in the midst of a deadly pandemic. And that figure represents up to 10% of the American public. So these protests, of course, were unprecedented in their size, their scope, and their duration, but they're not unusual. Many of you, of course, know that there are lots of instances in which police violence against individuals has triggered uprisings across the country. It's happened for decades. Many of you probably remember the 1991 beating of Rodney King by 4 police officers in Los Angeles that spurred the subsequent 1992 riots that rocked that city when all 4 officers were acquitted of the charges they faced. Other instances of police violence against Abner Louima and Amadou Diallo spurred protests as well. However, it was the 2014 shooting of unarmed Black teenager Michael Brown by police officer Darren Wilson that brought police violence to the forefront of national consciousness and then placed it into the center of a sustained mass movement. And then we saw, of course, how additional incidents, just to name a few, such as the police shootings of Tamir Rice, Walter Scott, Alton Sterling, Philando Castile, Keith Scott, the deaths in custody of Eric Garner, Sandra Brown, and Freddie Gray, how all of those continued to spur the public to action even before George Floyd was killed. But not every victim of officer-involved killings attracts the attention and outrage of that George Floyd's death did. And many deaths go both unnoticed and unprotested by the public. For instance, Breonna Taylor, a young woman who was killed by the Louisville police as she slept in her bed because of a no-knock warrant that police mistakenly served at her home, she failed to garner either the local or the national attention that other victims had faced until George Floyd died several months after her. And so, based on the years of public agitation surrounding officer-involved killings, it's clear that the public pays attention to and protests these incidents in many circumstances. But then the question becomes, why do some cases motivate and mobilize the public and not others? So today I want to talk to you about my research, as I mentioned, that looks at some of the factors that lead the public to mobilize around victims of officer-involved killings. And here I'm relying on data from fatalencounters.org, which crowdsources data on officer-involved killings from FOIA requests, databases, and they investigate reports that are sent to them by the public and the like. I also then added more data and additional variables about each of the victims that Fatal Encounters had found that where the killings took place in 2016. And so I'm going to talk today about the universe of killings that took place in 2016, excluding some that were determined to be suicides, and others where officers were not actually involved in 3 or 4 where the officers were not actually involved in the killing. And so the data that I have here will allow me to test a lot of the factors that lead to victims getting protested and to hold other things constant and to account for factors that might confound the analysis. And so I use the literature on social movements that I'll explain to you in a minute. And I argue overall that the protest of victims happens when the political opportunity structure is ripe for mobilization in response to a perceived grievance. And that protest is facilitated by organizations that help to organize and mobilize citizens. And I argue that the characteristics of the victim in the incident, as well as the local context, affects the construction and mobilization of grievances that can lead to protest. And I find that there are statistically significant associations between victim characteristics and behavior, incident characteristics, and local context and protest. And so just to give you a brief overview of the theory here, which we can then use to kind of extrapolate the results to get an overall picture of what's happening. The social movements literature puts forth what's called a political process model to explain what happened, why protests happen. And there are 3 factors that explain protests: the development of a grievance, the organizational capacity and resources of the groups that have the grievance, and the structure of political opportunities that are available to that group. Perhaps most importantly for protest, at least in the model that I'm talking about here, grievances are socially constructed injuries or injustices. They must be perpetrated by a group or some identifiable entity, and they must be remediable through collective action. So here, these injuries and grievances aren't just readily apparent. They're constructed, and those constructions matter for whether a person gets protested. So to think about the many ways that a grievance can be constructed, first, there's a really important question that needs to be answered, and that is, was there even an injury? And the answer to this question in particular cases is closely tied to the manner of death. So the fact of an injury might seem obvious, given the fact that a person died in what we're calling an officer-involved killing. But, however, there are many circumstances in which people die during an encounter with an officer where an injury is not clear, such as excited delirium. Many of you may have seen the 60 Minutes piece on this. Excited delirium is a controversial medical condition that's, quote, associated with severe agitation and autonomic arousal. And it's usually brought about because of mental illness or drug use. At least this is how the story of excited delirium goes. And excited delirium has been blamed for sudden deaths in custody, but often subjects whose deaths are attributed to excited delirium also were restrained, tased, or asphyxiated with chokehold or knees to the neck. And so it's the argument is not that the use of force caused the death, it was excited delirium. Other suspects may die of heart attacks, drug overdoses, or other medical conditions, and their deaths may be attributed to those regardless of whether force was used. We saw this in the defense of Derek Chauvin in with respect to his killing of George Floyd, arguing that George Floyd's drug use or his heart condition or even inhaling carbon monoxide led to his death, not the use of force. Another way that manner of death matters is that car accidents are another frequent cause of officer-involved deaths, and those may or may not be attributed to the officer's behavior. So once you've even established that the use of force, that there was a use of force that may have led to a person's death, there's also the question of whether, or the question of who is responsible for that use of force. Is it the officer or the victim? And so here we want to think about justified uses of lethal force. And blame is an important component of a grievance. And in order for the public to mobilize, they have to think about that killing as the result of a government action. They respond with protest only when they hold the government responsible rather than the victim. And so it matters, the circumstances surrounding an incident matters. In the current legal regime, for instance, that was ushered in by the US Supreme Court in Tennessee versus Garner, the Supreme Court dictated that the most important factor in whether the use of deadly force is justified is the dangerousness of the suspect or the victim. In Garner, the court found that an officer shooting a person to defend themselves or another person from imminent danger, that was a legitimate use of lethal force. And lethal force may also be used to prevent escape when, quote, the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. And so all but 12 states currently have a standard that follows or is close to that in Tennessee versus Garner. Others still have a regime in which officers may shoot any felon who's resisting arrest, including a fleeing felon. Just to very, very quickly gloss over those distinctions. So within that framework, though, the perception of dangerousness with respect to the victim is very important. And stereotypes of victims really do affect the likelihood that deaths are protested by affecting conceptions of blameworthiness. And the Supreme Court focuses on dangerousness as a key factor in which the use of force by officers is justified, but they even acknowledge in Garner, quote, the practical difficulties of attempting to assess the suspect's dangerousness. And assessing dangerousness is difficult, not just, because you're in a moment, it's difficult to do that in the field, but also because conceptions of dangerousness are related to stereotypes about race and gender and other characteristics. And those stereotypes about victims can influence whether people interpret police actions in a given case as just or unjust. Particularly, race is key to evaluations about the justice of an officer-involved killing. And a lot of research has shown that African-American suspects are perceived as more dangerous than white suspects, and that police in the field evaluate them in that way. And that racial stereotypes about Black people affect how white observers view police use of force as well. But there's a lot of recent research that has shown that campaigns by Black Lives Matter have moved the public to view officer-involved killings, particularly of Black victims, with greater suspicion. Gender is also related to how we think about dangerousness, particularly because female victims are constructed as defenseless and vulnerable, while maleness is associated with dangerousness. Victim age can work both ways. Both the very old and the very young are constructed as less dangerous, but mock jurors still favor harsher punishments for homicides of younger victims relative to older victims, And that's thought to be because the desire to punish people who kill young victims more harshly is attributed to the belief that these deaths are more tragic because more years of life are lost. Finally, the certainty or clarity with which observers can judge whether a use of force was justified also matters. And on this topic, the presence of recordings, either audio or video, may make a difference. But interestingly enough, the research shows that the effects of videos are mixed, and people tend to approach them with whatever filters or biases they already hold to. So the rest of the political process model, I'm not going to focus on as much here, but I will just say the importance of organizations is paramount, as many of you know, because you were here and know how organizations have played such an important role in mobilizing for victims of officer-involved killings. Black Lives Matter is the most famous group that routinely organizes protests, but other groups such as the National Action Network has done so as well. And these organizations can engage in all kinds of things, including mobilization campaigns for get out the vote in support of police reform. And these organizations, through their repeated interactions and their development of strong ties with other organizations over time, can really build long-term social movements. So that, and these movements are essential for sharing knowledge and resources across time and space, and for linking activists to extensive networks of members in both their home city and in other places. But what happens, though, sometimes is that the lack of this kind of infrastructure can also produce different kinds of mobilization. So McAdam argues that they might just, if you don't have these long-term, these networks with these long ties in a community, they just make ephemeral outbursts and movements such as riots. On the ground, many activists note that some unjust killings just don't get protested when a city doesn't have rapid response activists who can have the manpower to continually protest. I want to point out something else too that I'll come back to in the end is that a lot of the work that organizations do is that they publicize incidents and make people know that a death has happened, and also to help us think about the circumstances. Briefly, with respect to the structure of political opportunity, that usually refers to things like the openness of mayors and others to reform and conversations about violence, but it also refers to political repression. So how protests are policed, and whether people are expecting that they might be subject to violence, which has been a real concern with Black Lives Matter, especially given the way that people have been targeted by police, but also, by counter protesters who were like running over people in cars and the like. So now that I've gotten a lot of the theory out of the way, I want to talk about the data. So I, again, looked at the fatal encounters data, considering only victims killed in 2016. And even after excluding quite a few people, again, for suicides, and they don't quite fit the definition of officer-involved killings, I still have over 1,284 people who died in an officer-involved killing in that year. Some of the data that I added to these victims includes, first, I looked up everyone to see if they trended on Google in their local area or nationally, just to see what kind of public attention they received. And also, I and a team of research assistants, at least everyone had coded each victim for a threat assessment, and every victim had at least 2 coders. And so they were people who, we looked at the circumstances of the death according to a coded rubric, and everyone who received either a 1 or a 2 was coded as either low or no threat, and everyone S3 was a high threat. Typically, low or no threat is something like they were unarmed, not fighting. They were a bystander. There was the victim had no culpability at all in their deaths as a one, or two. If they were coded as two, it would be either the victim or the victim and the officer were both partly responsible for what happened. So the officer, the victim could have been, fighting with an officer, but then the officer made a mistake, or the victim was, so there was where both, it was kind of mixed in the sense that the officer at least bore some responsibility for what happened. So any case in which the officer bore at least some responsibility for the death, we coded as one or two, or low or no threat. We also added data for each case about whether an audio or video recording was available. In most cases, those videos were made available to the public, and they were from a lot of sources, including 911 calls, cell phone videos, body cameras, surveillance cameras from surrounding areas and the like. A lot of those recordings, we did not include recordings if they didn't capture the incident, or at least show some relevant part of the aftermath. So just to kind of briefly characterize the data, one of the things that you might know is that the victims are disproportionately Black relative to the share of Black people in the population. So Black people make up only 13.4% of the US population, but were 29% of officer-involved killings in 2016. Similarly, non-Hispanic white Americans are underrepresented. White people were 60% of the US population, but only 50% of the officer-involved killings in 2016. And other groups were only slightly misrepresented. Asian and Pacific Islanders were about 2%. Native American Alaska Natives were about 2.3%, and Latinos were 15.7% of victims. And the victims are also disproportionately young. The median age of the sample is age 34, but Black and Latino victims tended to be younger overall. And when women were underrepresented among the victims of officer-involved killings, only about 8% of the population was female. Now, with respect to victim culpability, 554 or 43.1% of victims were coded as not at all or partly responsible for the incidents based on their threat level and officer behavior. So 43% low threat. About 35%, there was a recording available, and an overwhelming number, 77.1% of the victims died from gunshot wounds, 15.6% died in motor vehicle accidents, and manner of death varies by threat level. So about 27% of the low culpability victims died in car accidents, compared with only 6% of high culpability victims. Those 6% tend to be suspects who were fleeing, who then either crashed their cars or the officer, they somehow got in an accident while they were fleeing. Another thing I want to point out is that public attention to victims trending on Google is also much more common than protest. About 45% of victims trended on Google. Again, a lower number than you're probably expecting in the weeks and months after their deaths. But only about 8%, 8.3% were protested. So looking at protests here, this chart shows you the light orange is for trending on Google and the dark orange is for protesting. And I'm sorry this is so hard to see. I should have made the fonts larger, but by race. And as you can see here, Black victims, and I'm kind of not relying so much on Asian and Native American here because the sample sizes are smaller, so those estimates are a little more unreliable. But Black victims to the far left are much more likely to both trend on Google and get protested. than victims of other races. 73 of the 106 protested victims, almost 70%, were Black. And Black victims, as I showed here, are protested at a much higher rate. Almost 20% of Black victims were protested, compared with 2.5% of white, 6% of Latino, and 10.3% of Native American, and 8% of Asian victims. And when you start to look at models that estimate what the effects of all of these different parts are of the how all these different factors interact, models that control for victim age, victim race, victim gender, threat level, other characteristics of the incident in the area, such as the poverty level of the area, the police, whether the police had complaints against the police, crime rates in the area, just whether there was a court recording or a gunshot. Controlling for all of these different kinds of factors doesn't make the relationship between race and threat level go away. Race and threat level have a statistically significant association with the likelihood that victim is protested. So in this figure, I am predicting, based on the models that the multivariate models that I showed here, whether a person is likely to be protested based on their race and their threat level. And for each group, the orange bar is for high threat, the predicted probability of getting protested for the high threat, and the dark orange is the predicted probability of being protested for low threat individuals of that race. And here on the far left, for Black individuals, you can see that almost 12%, they're almost, even low threat Black people, almost 12% of them should be protested at any given time. And that's just predicted with the people who are kind of least, the baseline, the people kind of least likely to get protested. So people with age 34, male, not killed by gunshots. If we do things like make it so that that victim is killed by a gunshot, it increases the likelihood that someone will get protested by almost 20 percentage points. If we add a recording instead, that it increases the likelihood that that person will get protested by almost 10 percentage points. But if we look at a low threat person where there's a gunshot and a recording, their likelihood of getting protested jumps dramatically. It comes close to, because this chart shows addition, it comes close to almost 10%. It comes close to almost 50% likelihood that they'll get protested. Very quickly, I want to talk about the role of gender, because I did bring up Breonna Taylor. And gender is an interesting phenomenon, and the circumstances surrounding the deaths of the small subset of female victims are distinctly different from those of men. Like I said before, only 107 victims were female, and 73.6% of them were coded as low culpability. And more than half of female victims were killed in car accidents. They either tended to be bystanders, like there was a police chase and they got killed. They were like a bystander in the way who got killed in a police chase. But there were also several women who were victims of off-duty intimate partner violence, which is different from how men were killed by police. And they happened to have intimate partners who were police officers who killed them. We also saw, because of these relationships, that gender is not statistically significant overall. But when you kind of take all of that stuff away, the few female gunshot victims or who were victims of on-duty violence were more likely to be protested than men. And so that gap is pretty large. It's about, the female victims are about 17.2 percentage points more likely to be protested among Black victims, and about 5 percentage points more likely, and about 10 percentage points among white victims, and about 10 percentage points more likely among Latino victims. Last couple points, age is negative and statistically significant, and organizational capacity are positive and statistically significant. And so I just want to finish up here because I'm running out of time a little bit, but I just want to talk to you very quickly about the importance of these findings. And first, what we see is that victim framing, how we think about victims and what they do, is very important. And the questions of threat level, who is a threat and what counts as dangerous, are really important for shaping how the public responds to officer-involved killing. And that's where the role of organizations becomes so important, because they are pushing back on narratives and helping to shape the public construction of particular victims as dangerous. So we see in tweets like this one, the contrast between Dylann Roof and George Floyd, and making us and pushing us to think about and contest how George Floyd was treated and how he's characterized based on his race and his behavior versus others. But we also want to think about, I think it's important to note, if we think that protest is an important tool in determining who gets justice, we want to think about the limits of protest, both in terms of how it's distributed, who gets protested. Does that mean then that only certain segments of the population get justice? So variation in terms of gender and race and age, and biases, even in how the public selects people to respond to, might in fact lead to a different kind of injustice for certain kind of victims who have trouble mobilizing the public. So with that, I will stop. And thank you all for your time and your attention.
I want to thank Dr. Burch, Sarah Stout for their presentations today, but I also want to offer a special thank you to our sponsors. Changemaker at the highest level, we are very grateful to Baker and McKenzie. At the innovator level, we have DLA Piper, Neon One, Latham and Watkins, Sidley Austin, Harrison Held, and PwC. Our pro bono partners include Goldberg Cohn, Kirkland and Ellis, Foley and Lardner, Miner, Barnhill and Galland, and Raymond Lind, former co-chair of the National Appleseed Board of Directors. Our allies are Ron Futterman and Sonia Nair, and our friends include Aviva Futorian, Roger Lewis, Matt Daniels, and myself. I want to end our session today to ask for your help. To offer your time and expertise, please contact us at CAFFJ, Cat Apple Frank Jack at chicagoappleseed.org. But we need your financial assistance as well. Please go to chicagoappleseed.org/donate, or just go to www.chicagoappleseed.org, and there is a donate button there. We do need your help. We appreciate every dollar. For more information about the Collaboration for Justice of Chicago Appleseed Center for Fair Courts and the Chicago Council of Lawyers, please check out www.collaborationforjustice, all one word, .org. Thank you for joining us this afternoon.